Well, they haven't stipulated, but
It's possible that we would put on rebuttal evidence, but we won't put on anything. If we put on new evidence, it would certainly be in accordance with the schedule that would be created, and we would do so on the time. If there's a staggered time for putting on new evidence, rebuttal type evidence, then we would follow that schedule. But I can say right now, we don't anticipate putting on new evidence because we put on all evidence against Woods when we initiated the proceeding. So it may be worth getting to the last possibilities of what may happen, but we don't have new witnesses, we're not doing an NOI, and if we're going to structure the rebuttal process, we would follow that if we did put anything on. I don't anticipate it.
Okay, so thematically, I guess where I'm going is the general principle that if there is new evidence, whether it's rebuttal or otherwise, whether we as existing parties would have the ability to cross-examine those witnesses. And so, and I don't need to take the time of the board today to say, map out, step by step by step by step in this, every word in the second act of the play or the third act of the play. But just thematically, if we all understand, new evidence is subject to cross-examination by all parties, existing or new.
We would stipulate to that.
Yes, only the landowners who are new can cross on previously discussed topics, but everybody can cross on new evidence.
Okay.
We could stipulate, or you can tell us that's what it is.
And I know I can rely on you all to determine what's new versus
We're all going to
prior
compare notes
existing.
afterwards.
You'll let us know.
yeah, right, exactly. And all things will be clear in this letter. And so that takes care of the scope for cross. Now, timing of rebuttal. And right. I know, it's not. But in terms of timing for rebuttal, well, actually, let's move on to evidence submittal date, because I think that will get to some of the timing issues. Currently, the submittal date of evidence is May 8th, 2015, 1 month before the hearing starts. I would like to hear suggestions on dates that provide for both new evidence, but also rebuttal, we were looking at well, anyway, certainly for rebuttal, for basically all the known things that you are planning to work on. We need to work out a calendar for when you submit these various pieces, and so. Right now, the only one that we had put into our notice for this meeting was the submittal of evidence on May 8th. But if we're going to move up, you're going to need to see the evidence before you can figure out your rebuttal, correct?
Yes.
So, suggestions?
My suggestion is if you're going to maintain the June 8th hearing date, the only logical date for submittal of rebuttal would be May 22nd. That's 2 weeks after the submittal of new evidence and 2 weeks before the hearing. I am concerned, however, that that's a very tight schedule. I'm concerned that it will be difficult for the parties who are preparing rebuttal evidence to get it organized in a logical and meaningful fashion in 2 weeks, and for those of us who have to prepare to respond to it to do so in 2 weeks. If the board is interested in pushing the hearing date out, we could accommodate those concerns, but absent that, I see that as the only option.
Yeah, what about moving evidence?
Yeah, if we tried to move it forward at this point, I will tell you that we have already accommodated all of our witnesses' schedules, and they have booked other things working around the May 8th date, including vacations and other testimony. So it would be extremely difficult for us to go move up.
Because I'm worried about the amount of time for preparing rebuttal. Any other comments from constructive recommendations?
I only hope it's constructive, and I don't want to short shrift the board on this, but I think that because rebuttal evidence would be considered probably very completely in an actual hearing and or oral presentation, there may be an opportunity to give more time before the hearing, say 3 weeks from May 8th, to provide that and take it away from the amount of time that precedes the actual hearing dates, because you won't necessarily need to become an expert on that, because that will still happen at the hearing. It's up to you whether you think that's appropriate, but this is as an adjudicative proceeding. It's not necessarily an expectation that you're familiar with every bit of evidence at the time it's presented, and it would be coming up with a full presentation. But I'm not suggesting that if it would any way short shrift you and your ability to be prepared having read that evidence. It just would give the parties more time,
Right.
robbing Peter to pay Paul, sort of, and you're Peter here.
So an alternative would be to have a 3-week turnaround to May 29th
It's
time
just a
frame.
proposal.
And I'd be interested in hearing from those who would be preparing rebuttal evidence besides yourselves. 3 weeks.
Yeah, I mean, it's hard to say, but I think in the spirit of trying to be constructive, I think 3 weeks could work. I'm more frankly concerned about the scope of rebuttal. I mean, in a normal circumstance, you have a case in chief, and then you have cross, and then you have rebuttal. So it's really hard. I'm trying to kind of wrap my head around what rebuttal would look like, and I understand we could put, testimony or responses of our experts and the documentation that we expect to rely upon. But if something did come up in cross, and if you get an answer you're not expected to, keep in mind that that's why usually you don't have to submit rebuttal. It's on the fly. So I guess closer to trial, I agree with, I think, what David was saying, which is usually you don't even have to submit rebuttal, so you can kind of push it closer and maybe toe that line. But I also want to make sure that we leave at least a small amount of wiggle room. If something unexpected comes up in cross, that we're not going to be cut off by our rebuttal submission.
I feel perfectly comfortable giving you all the wiggle room you need
Okay.
on rebuttal. But
Yes.
this is more about making sure we've thought through this, and the big things that leap out, you will have noticed, folks, and so we'll again be able to move more quickly.
That's right. Yeah, those things you can anticipate. And it's based on the written testimony that's prepared, there 3 weeks prior. And so that there's a logical, connection to that proceeding. And then, like you say, the nature of rebuttal is why it will be a wider scope than what you're providing ahead of time. And that's by its very nature. So we recognize that.
I have a personal plea.
Oh, granted.
Well, thank you. I'm just going to be very candid about this, and I'm mindful that rebuttal testimony isn't going to come in until later, and our hearing date is June 15. Is that, I'm sorry, June 9th. Okay. Right, I've got it right. I have a daughter graduating from college in mid-May back east, and it would be, and I'm lead counsel for our clients. And it would be, even though I have a brilliant team, difficult, candidly, to even with 3 weeks. And I wonder if it's at all possible that instead of 3 weeks, which would be the 29th of May, and then we also have a holiday in there as well, that we could get the rebuttal testimony in by June 3rd.
Works for me. David? What were you planning to do over the Memorial Weekend?
It's always this, if it's not something else I'm doing. I don't have a strong opinion. Again, it was just a proposal to give the parties more time to submit rebuttal evidence. On the flip side, and anybody who intends to submit a lot of rebuttal evidence, so probably the parties to my left would speak most to that, I think we were talking not long ago about the possibility of having them be case in chiefs anyway. So I would imagine that 80 to 99 or 100% of that evidence, if people were planning on putting it on anyway, might be able to be prepared in advance on the assumption that if it weren't being done as rebuttal, it would have been ready to be presented. But that would still mean that there'd be the possibility for rebuttal that would come on the fly. So I imagine people wouldn't want to give up that opportunity. But I do think that the board can consider, or my thought is that a lot of this evidence was probably going to be prepared or available to be prepared in advance if it weren't termed rebuttal anyway. So that's sort of going against what I previously said, but
Right.
If you're going to categorize it as
I'm
rebuttal, you can
I'm
go either way.
inclined to honor the request.
That's right. You know, and you know, in certain circumstances, there is a possibility that you would review the written testimony and determine you don't need to submit rebuttal evidence, so that you can handle it through the logical rebuttal process. But this gives the parties that additional due process that you may take advantage of or not, and it's your choice. And so I'm very comfortable going to June 3rd with that.
I would just like to say I appreciate the concern about scheduling. I have no problem with June 3rd with the following caveat. If we receive written testimony that consists of a 100-page expert report based on some hydrologic model, I am going to be coming back to you and asking for a recess of the hearing before I have to cross-examine yes, it would be cross-examining their rebuttal witness, because I frankly will be spending the time between June 3rd and June 8th preparing my witnesses that will be presenting evidence in the case in chief. And so I will have very little to no time to digest what's in that rebuttal testimony. I don't anticipate that to be the case, but if it is, I will have to come back to you and ask for that recess.
Of course, if they have that 100-page testimony at rebuttal and they don't send it in ahead of time, you're going to be challenged at the same time. So, but I think everyone here is going to be reasonable. So I'm operating on that assumption.
And if not, is it our job to make sure things stay reasonable? Okay, so we'll be involved.
I'm sorry.
Sure, go ahead.
We had been talking about something like revised NOIs, and now that we're talking about a rebuttal evidence submittal date, are parties going to be submitting something like an NOI to accompany those? Was that the assumption or the intent? Or no, just the evidence itself? Okay.
That was my intent, but do you any addition? I don't think so. Okay. Almost finally, closing statements and briefs. At the close of the hearing, we may allow oral closing statements or legal arguments, or set a schedule for filing legal briefs or written closing statements. Let's, in the spirit of making this as efficient as possible, do you have any comments about submitting closing statements, and if there should be some limit in terms of pages and format and whatever?
And also schedule, right? Correct.
And a schedule, yep.
I actually think that both pre-hearing and post-hearing briefs by all of the parties potentially could be useful. At a minimum, post-hearing briefs by the parties. I think sometimes the schedule has to be set after the hearing when you
Right.
see how much stuff's come in and maybe what other schedule issues are involved. I anticipate that we may have a very crazy spring, summer in the water world for other reasons. So I would strongly support briefing and setting the schedule at the close of the hearing.
Any comment on that? Yes.
We concur completely, but I would go one step further. We do think that opening briefs should be submitted and by all parties who want to, and we can set a deadline for that on the calendar, and then we can.
What would be your recommendation for a deadline that would fit your schedule?
It could, I'm very flexible on that,
Okay.
honestly.
As long as it's
just
not the
at a
29th of
time that would
May.
be- a time that would be most efficient for the board, so I would take direct, because the point of the opening briefs are to help the board understand the case going into it, so I would defer to the board's preference on that. It's just the opportunity to present an opening brief, and then we concur closing briefs, again, for any party who wants to do it, and page limits should be set, and that schedule can be determined after the evidence is closed.
Do you feel the need for opening briefs?
I don't feel strong need to compel them, but there's a lot on the record we have to work with, but I'm open to the idea.
Can I just reflect our opinion briefly? I don't think it's going to change anybody's mind necessarily, but I think that if seeing as how you don't want opening statements, I think opening briefs would serve essentially the same function, and everybody will be reviewing the record to know where we are and how we got here. So I don't propose that we do opening briefs at all. As to closing briefs, I think that there's certainly additional or added certainty to specifying up front whether you want them or not, as opposed to doing it on the last day so that people aren't taken a little bit by surprise and having to do an oral closing statement. But if this proceeding is anything like the first one, I think briefs would certainly be appropriate. The scope of that was gargantuan, and this may be narrower because some issues have been looked at already, but it may not, on the possibility that it's going to be even close to the same scope, or people will be addressing the same types of issues again, because that is potentially raised by should a CDO issue and what should the terms of that be. There will probably by necessity be some rehashing of things that already went on. I would say briefs are probably most likely appropriate. Closing briefs.
Closing briefs. Yes.
Perhaps I can add a little more specificity to what we would like the opportunity to do at least, and that is to present an opening brief that sets forth legal issues. We wouldn't want to do some sort of opening brief that takes the place of an opening statement that gives a great big recitation of the evidence and the facts and all of that, but an opportunity to brief the legal issues at the outset of the proceeding we think would be very beneficial, and we are asking for that opportunity to do so.
Go ahead. Sure.
So, are you hoping to have opening briefs where we would make rulings on legal issues prior to the hearing?
No.
So, but you would be raising legal arguments that are different than the ones that the parties raised in closing briefs before, and that were raised and that were considered in the board's previous orders, and then on reconsideration and sort of the decision to reopen this? I mean,
We would like the opportunity. We don't, again, we're not looking for you to do more work and to redo a lot of work. And we are mindful and very appreciative of the comments that have been made throughout today about your commitment that you are going to re-examine all the evidence and see what it means, what the evidence means, the old and the new evidence that comes in. We think it would be helpful, and we would like the opportunity to submit a short opening brief that sets forth the legal issues, that is not redundant or duplicative of what was done before. But it's been a long time. We are restarting an involved process. There are multiple parties. The issues are very, very critical. It's part of the whole policy of why we're even here in the first place, with understanding the water rights in this narrow proceeding. We got that. But it's very critical, and we would like the opportunity to have a written submission ahead of time that is not repetitive, and that is where we are today.
If I just may add one thing, I'm not sure it's critical, but I think an opening brief may also help frame how the landowner issue is going to be included and how it may change the CDO. If the prosecution team is not going to put on new evidence or put on a proposal of how to treat landowner evidence in respect to the existing CDO or how it will change the CDO, if they're not going to do that as a party, I would like to have the opportunity to submit an opening comment of how I think or my client thinks that the landowner information should be incorporated in either change it or informing a new CDO. That's a really critical issue for me, and I think it sounds to me like we could still not be on the same page of that going into this hearing. And if we're not, it would be helpful to have the opportunity to kind of phrase that, or at least phrase our position of how that should look to the hearing officers before starting.
Is there a possibility that this could go on your list of things to consider for stipulation? I mean, it's because you might need to do this, but you might not need to do this. It seems, I'm not sure I know, but go ahead.
I frankly don't understand that explanation. It seems to me that whatever the law is that needs to be applied to the facts and whatever the recommendations are that need to be incorporated into the final CDO, those would most logically be argued in the closing brief. Sometimes there is a good reason to present an opening trial brief. Typically in a trial, the reason you do that is because you have not provided the judge with written testimony. So the purpose of the opening trial brief is to provide a roadmap to the court of the evidence you're going to put on. However, in this proceeding, we already are doing that by submitting the written testimony, which I'm assuming you're going to be spending a lot of time reviewing. And so I don't know that the opening briefs are necessarily that helpful to you if you really should be focusing on reading the written testimony. If there were legal issues that you wanted the parties to brief, that you felt needed to be resolved in order to resolve this case, those are the kinds of things that I think could be done in a pretrial brief. I do agree with that. The question is right now, I don't know what those issues would be. And frankly, I would want you to dictate to us which issues you want briefed, as opposed to one party pontificating its view of the law to the exclusion of the others. So if there are legal issues that you want briefed, please ask. And I do agree that that would be appropriate in a pretrial brief. But other than that, I think the fact that we're submitting the written testimony gives you the roadmap that you would normally have in a pretrial brief. Closing briefs, I think, are exceptionally important. And if we weren't doing them, we would have to have very long closing statements with PowerPoints and so forth. You know, this, with a closing brief, it allows us to give you an outline form closing statement where the leaves on the tree are in the written brief.
We will definitely, 100%, definitely have closing briefs. Yes, go ahead.
If I might have another comment on the importance of opening briefs. It also will help you have the correct framework to evaluate the evidence. It's one thing to hear all the evidence and then get the law and everything afterwards and have us tell you what you just heard and tell you what you're supposed to do with what you just heard after you've just heard it and you probably made up your own mind anyway. So, but it's an important thing to do. But going into it, this is, again, a very important proceeding. The issue of water rights is so important and difficult to begin with. And being able to have the framework, the foundation laid so you understand the way to hear the evidence and what is important, I just think it's going to facilitate the process. It's going to facilitate what is relevant, how things move along, and I think it'll also require the parties in their thinking to sharpen how they want to present the case and what is relevant, so it doesn't turn into a free-for-all through the cross-examination process or otherwise. And we would like the opportunity to help set the framework. especially since we're not going to be able to do an opening statement or put on a case in chief.
Well, I'm not really hearing, you know, a unanimous point of view on the idea of an opening brief. But, you know, just to reinforce the issue of the closing brief, it really is important, but I look at it as a way to, you know, really do the integration of the previous proceedings with these proceedings. And we can't know, you know, and that will help us all bring together the loose ends and create a picture from everyone's point of view. So that's really the great value added. On opening briefs, I'm hesitant to embrace that because I feel that the interests of the different parties are served in an imbalanced way with introducing that vehicle of an opening brief. I think it serves the different parties in different ways, whereas a closing brief is an equitable process for everyone. So I'm actually leaning against accepting opening briefs for this phase.
This
of
is a nice
proceeding.
balance, because I was kind of leaning in. But
Sorry.
maybe how, we don't want a whole lot of extra paper about the law, and how we should be listening to the new testimony that would be coming in from the landowners. We do a page limit usually on closing briefs. You know, how short could something that you might put forward be?
We could do it in under 5 pages.
Under 5 pages.
Oh, for opening.
Opening.
Yeah, no, closing. I couldn't give you a page
Question is
limit today.
1 or 2
You're
zeros
gonna be
after.
impressed,
No.
aren't you?
And I'm not asking
Bullet
for
point,
closing.
single
No.
space,
Oh, I'm
font.
working on 5. So under 5 pages for opening brief. My inclination is to allow it, but I want to make sure.
Comment with the hearing officers previously set a 30-page limit per party, but finally determined that that 30-page limit could be exceeded if the parties were inclined to present a joint brief, and that third-page limit could be exceeded to 38, 40, something, nothing externally larger than that, but that's something that the hearing officers can decide at the close of this particular hearing. So just for expectation purposes, that's about the limit.
I like reading legal briefs, obviously, because I'm a lawyer and I signed up for that. But there has been an extensive amount of briefing in this case. And what I am hesitant about in just saying sort of bring it on, and give us new ways to think about this, is I'm a little worried about frankly, the burden on the new landowners with preparing a case in chief, responding to a very short deadline that we're talking about in terms of rebuttal evidence. And I know that we don't always even have a rebuttal evidence submittal before the hearing, but for those of you that were at the hearing last time, and for those of you that have followed it, a lot happened in rebuttal in the 2010 hearing. And that rebuttal evidence ended up being, as for everyone who's read 2011, 15, whatever, 5, thank you, David, ended up being critical to our decision. And so I'm a little concerned about adding sort of another avenue when the landowners are preparing direct and responding to rebuttal. And so I'd sort of like to hear from you all on that. And I'm wondering, there could be some way, to put this way earlier where it wouldn't interfere as much, right after stipulation, for example, to submit a 5-page brief, so it doesn't interfere with sort of the immediate getting witnesses ready and responding to presumably significant rebuttal evidence. Or what are you all's thoughts?
If there is going to be a pretrial brief, I would like it earlier. I would like it to be 5 pages or less, and I would like it to not comment on the evidence. Because frankly, I won't have time to write a brief, even of 5 pages, that comments on the rebuttal evidence between the 3rd and the 8th. So if they are going to be submitted, I would say submit them earlier. I'm not sure how valuable it will be.
But that would fit within your time frame as well, correct?
Absolutely. We can submit them in April. We would accept everything that was just said about it, that they wouldn't comment on the evidence. It would be legal briefs, that they would be 5 pages in length, or not to exceed 5 pages, and whatever date that you wanted between, I would just say the end of March, so we have an opportunity to advance as much as possible through the stipulation, and the beginning of May, whenever you want it in that time frame is fine. I mean, it's absolutely possible. I'm just to throw this out, and haven't conferred with Jennifer about this or Dean at all, or the prosecution team, but maybe we would come up with what happens in court often, an agreed statement of the case or the law. And it's just something that we collectively say, this is what it is. And I'd like the opportunity, that would obviate my concerns for an opening brief of any kind. So I just allow us to be creative, work through the stipulation process. If that can be reached, great. If not, then we'll have a deadline by which to submit a very short, purely legal brief.
I'm comfortable with that.
Sorry, I was
Go ahead.
just going to weigh in, but if you already know what you want to say, then that's...
So what? No, new
um,
information is always helpful.
Okay. I think this is a tiny bit duplicative of what I said before, but I think that even though the key issues noticed for this hearing are somewhat different than the key issues that were noticed on the original hearing, I think that those turn largely on evidence, and something that precedes the evidence or doesn't discuss the evidence is really just going to outline where the parties are coming from and trying to go, and I think you already know those things based on the extensive proceeding that's already come. So I don't see the same utility, although I'm definitely open to talking with the other parties about stipulating to something, but a backstop of submitting something, whether early or late, I don't see the same utility, but that's because I don't have...
But do you see
need
a
for it.
damage?
Just to my ability to work on it, but
Okay.
that's, if you
Okay.
want it, I'll do it.
Okay, I accept that. I think this should go onto your list of things to talk among yourselves on, and if we can avoid it, that makes it all the better. But if personally, I think that if you still feel a need that the law, that you need to lay out some in an opening brief, some of the legal background that has not been laid out before, I'm willing to take it in.
Okay.
And we'll set an early date. It'll be in April, so it'll be well before you need to be wrapping things up. Okay.
So I'm sorry, if I understand, we're going to meet and confer about it through the stipulation. If we get a stipulation, great. If not, we'll state in whatever we submit to you that is a stipulation. The parties propose this or propose that and let you make a decision, knowing that any brief will be planning for early April and very short.
Correct.
Okay, thank you very much.
Vice Chair.
Oh.
Sorry, Vice Chair Weber. Over here. Sorry. I was just thinking it might be nice to have some kind of drop-dead stipulation deadline for all of this to hinge on. And the other point I want to bring up that I've heard is still the discussion of a pretrial brief or another pre-hearing conference. And I was under the impression with the closeness of the rebuttal deadline that we were not going to do that. But if I'm unclear about that and the other parties are unclear about that, it'd be nice to know that we're on the same page.
Yeah, the subject of the subsequent pre-hearing conference revolved around the timing of testimony, and it sounded like that was going to be, resubmitted along with the written testimony, and perhaps and then the rebuttal testimony that's submitted. And so again, I reiterate that I'm not clear that another pre-hearing conference is necessary.
And it may not be, but we can't totally rule it out if we need to pull folks together, we'll have to do it. But we won't schedule it for sure right today. And we'll hope we don't have to. That would be our goal.
I did have a question before you move on to your last. And for the parties, there was, in preparing for this conference, one of our questions in looking at the witness lists and that sort of thing, and the discussions we had about prior testimony, new testimony, but also, in the with the goal of expeditious hearings, is there a possibility of having them testify or be available in a panel format?
Oh, right.
Just I was, generally speaking, and if you want to offer specific examples of where it would or would not work.
I think in the past we did a number of the witnesses in this proceeding, or at least in similar ones, as a panel. We're definitely open to that.
I would be opposed to a panel. I think in this case in particular, when you are dealing with expert testimony and the need for cross-examination, it's much cleaner if you're looking at one witness at a time. And it gets very confusing if you're trying to do it as a panel.
Yeah, I would just concur with that. It's not in this type of proceeding and what's at stake and the heavy expert-laden testimony. And I don't think it would work very well.
And we share the concerns of Jennifer and Dean down there.
Okay.
Thank you. Appreciate that.
Prosecution team, unless
You are welcome to use a panel.
Ours as a panel. Our expert witnesses as a panel, and people can say yes or no.
Everyone doesn't have to do the same thing. That's very good. Okay, finally, in terms of ex parte, we want to remind the parties that there shall be no ex parte communications with state board members or the hearing team staff or the supervisors of the hearing team staff regarding substantive or controversial procedural issues, either the substance or the procedure, within the scope of the proceeding. Any communications regarding potentially substantive or controversial procedural matters, including but not limited to evidence, briefs, and motions, must demonstrate that all parties were served and the manner of service. Just common, normal ex parte stuff. So the veil has come down. We are here. We are in that world. Now, does anyone have anything that I have not covered that you need covered?
Yeah.
Yes.
Just getting back to the question of the date by which you would like the stipulation on everything we've talked about.
We talked about meeting and conferring during February and having a date in maybe the end of March to actually submit to you our stipulations of law and fact. I would prefer the end of March. I know my kids have break for 2 weeks in March. We're going somewhere. So we'll be back and I could clean it up by the end of March.
I don't have my calendar in front of me. Do you have the
Or
calendar?
the beginning of April, either of those.
I like the end of March. I think that's good.
Does the 27th work?
I meant to bring it and I forgot.
27th, that's actually in the middle of the Tanaka trial. Yes. The best, the 3rd.
3rd of April?
Mhm.
As long as it's not April Fool's Day, that would be not good.
That is fine with us.
April 3rd.
I'll
Does
be
that work?
open through the 2nd, but depending on how long this is, and I imagine I will have seen most of it beforehand, I could probably turn that around. If we went out to the Monday after that, maybe. The 6th. Easter is Sunday, the 5th, perhaps the 6th. Just so in case something was new for me, I would have more than a day to turn it around.
Is the 6th okay?
Yes.
We'll make it work.
Okay.
So we know, when are you going to be gone? We need to get things to you before then.
Yes, we can do that.
I'm sorry, what was that? I didn't hear you.
The 5-page opening,
If it's still needed.
it should be submitted 5 days after the stipulation submitted.
The 10th?
10th, April
That's
10th?
Friday the 10th?
Mhm.
We will make that work.
Okay.
Thank you very much.
So here are the dates. We got the stipulation, April 3rd, 2015.
No, April 6th.
April 6th.
April 6th.
The 5-page opening brief, April 10th, evidence May 8th, and the rebuttal due on June 3rd. Correct?
Yes. And we did agree that when we submit our evidence and when the other parties submit their rebuttal, a revised time estimate, right?
Right. Okay, anything else? Okay.
I did have one other thing.
Oh.
I just wanted to inform you that all of the parties have been working on settlement proposals. And so obviously we're not going to talk about the details of those today, but I wanted to assure you that the parties were working diligently on them. And I'm very hopeful that, sometime before these dates kick in, we'll be able to come back to you and say, you can take that all off your calendar.
You can come back anytime you want.
So,
Anytime.
well, there may be, I just wanted to put that on your radar screen.
Okay,
That we
thank
may
you-
be
thank
coming
you.
back to
I didn't realize that.
with the settlement proposal. We are hopeful.
Well, we always encourage parties to confer and work things
Well,
out.
we'll have a party.
Yeah, on June 8th, yeah, right.
Oh, and just to confirm, you will be sending out a letter
Yes.
clarifying the issues? Okay, thank you.
And when can they expect to receive that letter that clarifies scope, et cetera?
Procedural issues, everything.
You can see who's writing this.
Today-
We will sign it, but
Today's a Thursday.
Yeah, we'll provide it.
I'm guessing you probably want this letter before you start your stipulation.
It would be helpful. And
Discussions?
I will need to clarify the drainage customer issue.
We could get just that issue out sooner, and then, but the sort of the reworking of the hearing issues, could that wait sort of?
January 30th? For your letter
everything.
clarifying the issues.
oh,
and
clarifying
scope of-
issues by January 30,
As well as the ruling on the
the drainage.
drainage customers. It's a little more than 2 weeks.
Okay.
We can do that.
January 30th, another date. Lots of dates. Well, I think we have finished, and if there are no additional procedural issues that we need to deal with, thank you for participating in this pre-hearing conference. I think it was a little bit longer than we had thought, but I think very useful conversation, and I'm pleased to hear that you all are working together to resolve some of these issues, if not all of them. And we'll be asking, if we need additional, anything additional, we will certainly come to all of you. And but at this point, I don't see anything else on the horizon.
Thank you.
Thank you. Thank you very much.